Okay, continuing part 3, maintenance and repair. Tenant shall maintain the premises in a neat, clean and orderly manner. Use and maintain the premises in accordance with all police, sanitary and other applicable regulations and restrictions imposed by any government authority and any homeowners association. Observe all reasonable regulations and requirements of underwriters concerning use and condition of the premises. So this one here, we will get, let's go through there. So tenants shall not use or permit any rubbish, waste, misuse of any fixtures, storage of flammable liquids. Let's see, tenants shall pay for and or reimburse landlord for any or all damages is a big part of this one here. Landlord may invoice tenants for the cost of any repairs or replacements other than wear and tear during the lease of the term. The amount of such invoice is deemed as unpaid rent, so those will become rent on there. So this is where the repairs and everything are yours except for things that are not wear and tear. So nothing in this clause shall waive or lessen landlord's obligation to maintain and repair. Repair the premises under Michigan law, but landlord is not liable when it has not been informed of the need to repair. There's that whole thing about this has been needing repair for X amount of time and I'm going to have a problem with it now. It's like, no, they are actually liable to tell you that it needs repaired. If it's not informed, they cannot turn around and say this has not been repaired for X amount of time. So landlord's reasonable exercise of any right or obligation hereunder shall never be deemed an eviction of tenants or interfere with their use of the possession of the property. So it's the rule in the law where you cannot come back at them negatively. So if they turn around and say something needs to be repaired or there's an issue with the property and it's deemed as something that is under your responsibility to repair, you cannot then evict them because of asking for that repair. That you can get in a lot of trouble for because you're retaliating because they've asked for something which is under the law. This part here is not necessarily applicable for us. However, it says if the term of the lease is for a period 1 year or more, tenants shall make necessary repairs and replacements in the premises. This, when it says 1 year or more, it's meant to be a year and 1 day, so it has to be 1 day past 12 months. If it's on 12 months, my belief, and this may be an attorney question if it ever arises, but my belief is that if it's 12 months, then it is the landlord's responsibility. As soon as it's 12 months and 1 day, then you can put it in here that the tenant makes all necessary repairs to the property. So most of this one is not going to be there. There is tenants at his own expense during the continuation of the lease shall also be responsible for routine care and maintenance of the yard. So this is in here is where they're responsible for snow removal, the lawn care, etc., to keep the property maintained. So there is maintenance and then there's routine maintenance. Routine maintenance is definitely the tenants. Landlord may invoice tenants for the cost of maintenance during the term of this lease. So if they fail to do these, that's when you can put in something. So say for instance they don't mow the lawn for a certain amount of time and then the city says that they're going to fine if it's not being done. You have the rights then to have that done and then put that on their rent. This is the pet section. Like I was saying before, I would just always have pets, because otherwise people are just going to sneak them in, do stuff like that. You might as well be getting something for it. As well as there's a few other cases where they could have pets, which then you can't stop them and you cannot change or charge them, for it. I do have the separate pet addendum, so we'll go over that in a minute. This is the keys part. So landlord may retain a key to the premises. Tenants shall not alter or change the locks of the premises without landlord's prior written consent. If the tenant does, they must provide a new key immediately upon its installation. So you have to get a key straight away. The same applies the other way around. If the locks are ever changed on the property, you're required to either immediately give them a key, or if they're, say, at work or something like that and it's the middle of the day, you're required to have notification on the door that the lock has been changed, and then you must be available to give that key to them as soon as they ask for it, no matter what time of night it is. So here's entry by landlord. This is the right to inspect. Landlords or the agent may enter the premises in an emergency to perform repairs, maintenance, code inspections, appraisals, or any other purpose reasonably done, except during an emergency or when the landlord reasonably believes there is an emergency. All entries made during a reasonable hours. So this is where you have your case of quiet enjoyment. And quiet enjoyment means that they have the rights to use the property, because this is what a lease does. It gives them the rights to use the property without being pestered or tormented or harassed. So in such cases, both parties must give reasonable access to do so. So if there's a repair that needs to be done, they can turn around and say, sorry, that time doesn't work for me, and then they could give a reasonable time that could work. Now, that could go backwards and forwards a few times, because reasonable time, they could turn around and go, well, I work, I need you to do it in the middle of the night, and that, with contractors and stuff, would not be deemed reasonable. If they do just turn around and say, no, I'm not accepting it, now they're not giving reasonable access to the property, under which you would then be able to look at an eviction because of that. So the next part is that the tenant agrees that for a period of 30 days prior to the termination of the lease, tenants will permit the landlord to show the premises in an effort to obtain a new lease. Tenants agree to allow the landlord to affix a rent or for sale signs on the premises also. This is a common one. Most leases have this, where once you get to the last month or so of your lease, they can actually start having people come in and look at it, and potential renters. It's definitely one that needs to be thought about. Hold harmless. So this is one where the tenants agree that they're not going to hold the landlord responsible for any damages which are done based on liability or any illegal uses or anything like that. So if they slip on the ground or anything like that, someone does something where it's not because of something that's not maintained or correct, if it's just because of normal parts and they've done something, hurt themselves, broken something or anything like that, the landlord is not held liable for damages to items or to people. So bankruptcy, if in the event the tenant is declared bankrupt, or the estate of the tenant passes to a receiver appointed by a court, the lease shall, at the option of the landlord, terminate upon 30 days written notice. So if the person does come bankrupt or anything like that, you do have the rights to terminate the lease if you so wish. Damage to tenants' properties. Landlord and its agents do not provide any insurance coverage for personal property. Basically, this is just saying that it's actually one of the next lines. Tenants are encouraged to insure their personal property and get renters insurance. I've seen ones where they actually have it where you're forced to. I don't necessarily feel that that's fine, because it's the same as if you have an old beaten up car, you're not going to pay the money to insure it. If the people don't necessarily have expensive items in their house or anything like that, then you're forcing them to have insurance for no really good reason. Alterations, so this is where any alterations to the property, so they can't make additions, they can't decide they're going to put in a closet tomorrow, they can't decide that I want to refurbish the bathroom or paint or do anything like that without getting your written consent. If they do anything like that, then that's grounds for termination. They will also be responsible for the costs that it takes to bring the property back to what it was. Return of premises. So the tenant shall return the premises and any furnishings herein to the landlord at the expiration of the lease. Tenants agree to provide 30 days written notice to vacate the property prior to the expiration. So if they do not plan on extending, then they should let you know 30 days beforehand that they are not going to continue or renew the lease. So the next part is any addendums need to be written in writing and signed by all parties. We have a few of those. Paragraph captions that will assist, so basically the names there, like captions, amendment, doesn't have any meaning on it. They're not legally, so you can't turn around and say, well, this means this, where the words say something else. It's the words in it that mean, not the actual names in front. The next one is the waiver, where if any one of these provisions are overturned, it does not mean that the rest of the lease is suddenly voided. The rest of the lease still continues to act. Severability, a court ruling that a clause of this lease is invalid, the parties' written agreements does not make the rest of the clauses. That is actually severability as well. So there's the two differences. So the waiver means that if you as a landlord decides to not enforce one part of it, it doesn't mean the whole lease isn't enforced. Like, you're not enforcing the whole lease, it means you're only enforcing that one part. Severability means if they decide that a part of the written lease is not valid, then the rest of it is not valid, does not become not valid. It stays working. Successors bound, so this goes to any of the successors, assigns, representatives who are bound. So here is the use and quiet enjoyment. The tenant shall be entitled to quiet enjoyment of the premises during the term of the lease. Tenant agree that the premises will be used for residential purposes only. The premises may only be occupied by the tenants and occupants named above. Tenants shall comply with all applicable laws and ordinances and refrain from all conduct that is unreasonably disturbs each other tenants, occupants, neighbours, or the landlord. It says that there's no business that shall be located in or conducted in the premises. To be honest, now a lot of people work from home. I wouldn't necessarily call that conducting business. They are working from home. Conducting business might be they turn the lounge room into a small factory producing items. I would look at it more like that, where okay, they suddenly turn this thing into, a mass production area. The joint and several liability means that if there's more than one person on there, one person goes away, it does not end the contract, it just transfers onto the others, and they continue to take a hold of that. Untenantability. I'm pretty sure they legally just made a new word. But if this is where I would call it uninhabitable. So say for instance the property burns down, something like that happens during that, then it may be terminate the lease by written notice to the tenants and surrender. And there may be sometimes where there may be the opportunity where you may have to pay for a certain part or refund a certain part based on that. Yeah, rent shall be abate in the same percentage that the premises are untenable. So say for instance the entire bathroom floods and falls into the basement, and they now have one bathroom instead of two, which isn't your case, you've only got one, but if there was one bathroom instead of two, then they have the right to have the lease and the rental amount reduced by the percentage that is unusable. The next part here means that they can't assign this lease to someone else or sublet the occupancy out to without your written permission. Abandonment, this is where if they do leave, so this is where if the rent's currently unpaid for and all the possessions are removed out of there, then you can actually go for abandonment. So if the rent isn't paid for 15 days and everything looks out of there, that's where you can actually then turn around and claim it as abandoned. I would be very careful with some of those and make sure that you consider whether, like, I would still put in the notices for eviction or that, but then use the abandonment ones. Go, okay, they've left, I'm now going to take back over possession of the property. So holding over, tenant shall vacate the premises on or before the expiration date. If tenant retains possession thereafter without landlord's written permission, landlord has 30 days from the last date of the lease to sue the tenant for possession. So this is a summary of the summary proceedings. If a suit is not commenced within that time, the tenant shall continue on a month-to-month basis from the date of the lease expires. So if they just continue, then they may actually be able to just go on a month-to-month, and you've allowed that, unless you then put in the 30-day eviction because the lease is technically terminated. And if they do go on a month-to-month, this also states that the lease, all items in the lease will stay in full force. So all the parts of this lease continue to go. However, the rent shall be increased by 50% beginning on the first day after lease expiration. So if they do stay and become month-to-month, this increases the rent by 50%. So this one, next part is limited cancellation rights. So if they've possessed the property for more than 13 months, they may terminate the lease upon 60 days written notice. So this is where they could actually terminate the lease once they've been there for longer than a year. Part 2 of that is tenant becomes eligible during the term to take possession of a subsidized rental unit in senior citizen housing and provides landlord with written proof. So say for instance Section 8, which is Shang Tsung's property, is Section 8. If the person got approved to a Section 8, which is very difficult to find a Section 8 for the tenant, then you should not stop them from being able to take that advantage in their life. As well as if a physician determines that they are no longer able to look after themselves. Part B is if they join military service, they could also go for it. As you can see with a couple of these, it lists where it is actually as a law. And then the next one is if any tenant believes themselves to be in the presence of danger for either themselves or their child from domestic violence, sexual assault, or stalking, they have then actually a law that covers that, allowing them to break the lease to not keep themselves at danger. And the other one is that if a tenant's job relocates them by force to, and it's hard to say by force, but there are certain jobs where it's difficult to do. You could be a manager, you could be something high up, where you're basically unemployed if you no longer take this job. This is not necessarily going to work for the person who works at Walmart or any of those types of things. This would be a manager or someone who's like in an engineering field, something like that, and they have to move at least 100 miles from where the house is. So in that case, they can terminate the written lease and notice the landlord with no less than 2 months and provide documentation from the employer to support that. Waiver of subjugation. Each party releases the other party from liability for loss, damage, or injury caused by fire or other casualty for which insurance is carried by the insured party under the policy, which permits waiving. So if there's a personal liability insurance, then they cannot then turn around and sue for the same thing that has already been covered. So non-liability, landlord shall not be liable for accidents or injuries to tenants, their family members. So if anyone they have around, they are liable for insurance towards the people who are there. Lead-based paint disclosure and moving checklist. We will get to that in a moment because that is another form that we are required to fill in. The next part is, this is the entire agreement. So unless there's an addendum agreed to by both parties, it does not become part of the lease. And then condemnation. If all parties of the premises is taken by any public authority under the power of eminent domain. So eminent domain is where the government forces a property to be sold for adequate and fair compensation, and in Michigan that is also for public use. So if they take anything on eminent domain, it has to be taken for public use. But then this will obviously allow the actual tenant agreement here, the rental agreement, to be terminated. Our other parts we have in here is no smoking of any substances on the property and no indoor plants or growing of cannabis without written permission from the landlord. If anyone gets a gripe or has anything about that, there is actually Public Act that supports that, and the reason that it is being put in there and used is because smoking obviously damages walls, paint, and interiors, and the growing of plants also does the same because it increases humidity, adds water to the property, etc. like that. So it is not being done for a factor of not liking smoking or plants or cannabis. It's done for the fact to protect the property from any extra damage which may happen from those things.